All right, good morning, everybody. A couple minutes past the hour, so we'll go ahead and get started. I just want to thank everybody for joining us today for our February webinar, When Employment Issues Need Legal Assistance, Using Your Liability Coverage. I'm Alex Schlucky with the CSD Pool. Today, we are here to provide you with a roadmap to understanding when an HR or employment issue is a big enough risk to your organization that legal assistance is needed. We'll also explain how you can tap into your membership benefits and access our pre-loss legal service to get the assistance you need when these issues become grave enough. As the title indicates, our pre-loss legal assistance is only available for members with liability coverage. However, this presentation still has plenty of valuable info that can help you understand what to do and when in order to avoid a costly claim. So if you're somebody that just has workers' compensation, definitely valuable information here to listen to. And later in the presentation, I'll also be discussing very briefly other HR resources available to you as a CSD Pool member, whether or not you have property liability, workers' comp, both, when issues aren't as severe but still require guidance. So today our presenters are Marnie Nathan Closer and Ashley Hernandez-Schlegel. Both are attorneys at Nathan Dumb and Mayer PC, who work with the CSD Pool to administer our pre-loss legal services. And we're also joined this morning by the CSD Pool's General Counsel, Diane Criswell, to round out any additional discussion points. Marnie became an associate at the firm in 2003 and was made a shareholder in January of 2007. During her time, she has specialized in presenting governmental entities across the state in a wide variety of matters. She's also served as an insurance defense lawyer, and she has engaged in the defense of a vast number of different types of claims, including civil rights claims, auto and premises liability claims, land use claims, and various employment matters. Ashley Hernandez-Schlegel received her law degree from the University of Denver, Sturm College of Law in May of 2011, and she was admitted to the Colorado Bar in October of 2011. Ashley was a judicial intern for Judge Christina Habas, a staff editor for the Denver Journal of International Law and Policy, treasurer for the Latino Law Student Association, as well as a member and competitor on the ABA appellate trial team in 2010. And we're very pleased to have them here presenting this important topic today. A few housekeeping items real quick, and I'll turn things over. We're recording today's session. If you need to step away or have technical difficulties, we'll send a recording out to everybody to access later on. PDF version of today's slides are available in the files box above the chat box. You can download that at any time. We'll be taking questions in the chat box, so as they come up throughout today's presentation, go ahead and we'll answer them, so go ahead and type them in as you have them. And we'll pause again at the end for Q&A as well. And so with that, I will turn things over to Marnie and Ashley. Thank you for being here today.
Well, good morning. This is Marnie speaking. It's a little different when we can't see each other, but hopefully it'll be less distracting for everyone. Ashley and I want to thank you for taking time out of your morning to be here as well, and we hope that today is useful for you going forward. As Alex mentioned, the purpose of today is to discuss, in my mind, when you should consider seeking to implicate your coverage with the special district pool, and specifically, if you should, whether you'd be looking at a pre-loss legal coverage or filing of a claim. And as Alex mentioned, feel free to put any questions in the chat, or we'll have time for Q&A at the end as well. So I'm gonna dive right in. There's a couple of slides, and we'll just talk briefly about them related to the coverage documents and the applicable language in them. And we did this just so you'd have them handy, but obviously, you know, it's best to always look back at your applicable coverage document in case there's any changes from one coverage period to another. But both with the pre-loss legal assistance and a claim, there are certain obligations and language that's applicable from the special district's policy. And so first, with respect to pre-loss legal assistance, it is limited both in the topics it applies to, as well as the amount of fees incurred per claim and per coverage period. So as discussed in the slide, this is really intended for use related to an audit, an investigation, certain administrative action, or other employment-related matters. And it is limited currently to $3,500 spent per matter and $7,000 per coverage period. So obviously this is different than a claim is, which has, much broader application of when it's triggered, and obviously different limits or amounts pertinent to it. Moving on to the next slide, we talk about policy duties. So this is what duties do you have as a member related to a potential claim or trying to implicate the pre-loss legal coverage. And, first and foremost, it's notice. Obviously, in order to trigger, you have to reach out to the special district pool and provide notice. And the extent of the notice depends on whether you're looking for pre-loss legal coverage or a claim. But in either event, notice is important. And it's discussed in various provisions in the policy language. In the next slide, you'll see, again, it's discussed in this language, and that in order to implicate coverage, the pool has to receive notice. And the sooner you provide notice, the more coverage you end up potentially having. Because there's, a distinct potential that if you delay in providing notice, you might only get coverage moving forward. So I always suggest that when in doubt about whether or not you need to provide notice of something, whether it meets the definition in the policy, you're always better to ask. And, the special district pool will tell you if it's not something that implicates a claim yet, but better to be safe than sorry later. So some additional requirements besides providing notice, you need to make certain that if you become aware of a lawsuit in particular, that you notify as soon as possible. There's obviously deadlines that get triggered with that, or an EEOC or CCRD, and certain other administrative actions, which is a little different than if you're dealing with pre-loss legal coverage, which would be before those matters occurred. Besides providing notice, you also are going to need to work cooperatively with whoever's assigned from the Special District Association moving forward with respect to either pre-loss or the claim. Typically, the adjusters do not do a ton during the pre-loss portion, because that's really for your use in getting legal advice as opposed to specific action that the pool may weigh in on. But obviously, when you get to the situation of a claim, there's going to need to be a cooperative approach between the attorney, you all, and the adjuster handling the matter. And the purpose is to make certain that the defense is handled in the best way possible. And, as members of the pool, you all are lucky, in my experience, working with both self-insurance pools like the Special District Pool and other insurance companies, because the Special District Pool is much more cooperative with its members than a lot of typical insurance companies are, who once you provide them notice, they take control and you're really along for the ride without much input. The Special District Association is much more cooperative in that regard. So this slide talks about you will not do things that cost money and expect reimbursement without first talking to the pool and providing notice. And this is important because you all don't want to spend money out of your budget unnecessarily. So this is one of those circumstances where it is best to not expect that you can take action and essentially ask for forgiveness or assistance later. So whether that means retaining an attorney or paying fees to your general counsel to do work that you want the pool to reimburse, or settling with an employee, you are best to provide notice and get the Special District Pool involved before you pay anything, or you may not be able to seek reimbursement. So with those general coverage provisions in mind, next we're going to talk about things to think about when you decide whether or not this is something that you handle in-house or whether you seek pre-loss legal coverage or a claim. So Ashley's going to talk about what is a normal employment issue versus what is one that may implicate pre-loss legal coverage or a claim. And then I'll dive into some more specific examples. Once you know you're going to implicate coverage, it's just a matter of which type, whether or not you want to implicate a pre-loss legal coverage or a claim. So with that, I will turn it over to Ashley.
Good morning, everybody. Glad we are able to discuss these things with you today. They're very important, and it's our experience that if you someone involved, an attorney involved in an issue before a claim is made, you've often set yourself up in a much better position legally to defend a claim if one ends up occurring. So I want to discuss with you guys and give a little insight in what we see about when an employee is either complaining about an issue or whether it rises to the level of a potential complaint that you should notify the pool and get your pre-loss coverage. So number one is that a complaint from an employee is more than someone just expressing general unhappiness or dissatisfaction with their job. That happens, that can be routine, and that does not trigger, something where there's a potential legal concern. The 10th Circuit has decided that employees are not entitled to a utopian workplace. They're not entitled to always get along with their coworkers or their bosses. Rather, employees have rights against discrimination, sexual harassment, hostile work environment, specific things that, those things cause concern versus someone just being generally unhappy with something or someone at work. So, when someone comes to you and there is an expression of general unhappiness, obviously, HR or whomever the person is coming to in terms of a supervisor, should listen to those concerns and determine whether something else is at play or whether there is any underlying potential for, a claim for hostile work environment, for instance. But if not, that is not something that would trigger your pre-loss coverage. A complaint, on the other hand, is usually, and we'll get into this a little bit more in the upcoming slides, just some general guidance and buzzwords you should be looking for. But when someone comes to you with a complaint, and those complaints can be either oral or written, you're looking for certain things that may trigger you and your concern over engaging your pre-loss coverage. And that's, someone coming to you and saying, I think I've been treated differently than so-and-so. And that's important because there's an indication there that there could be some reason why the person is being treated differently. And you want to follow up on that more to see what that person is detailing for you. And we've gone into the next slide, and this is some of the things, what to look and listen for. So, like I said, if someone's thinks that they're being treated differently, then you might want to think about, okay, is this employee who's complaining to me, are they in a protected class? A protected class is specifically defined under the law, and that's, some examples are, does this employee have a disability that we're aware of? Is the person's race a potential issue, or their national origin, their gender, or their age? 40 and above is considered within a protected class. If any of those things exist, and the employee is saying, hey, I think I'm being treated differently because I'm a female and my male counterpart got this and I didn't, even without necessarily saying the word discrimination, though that scenario should cause some red flags, some warning bells for you. And it would be best to contact the pool and determine, whether pre-loss coverage would be a good idea in that circumstance. And I would tell you most of the time it is. So then, some other things to look for besides, just the description of a potential triggering event that could lead to legal action. Is the employee complaining or disagreeing about a procedural or an operational issue? If that's the case, most employers are at will. If an employer is at will, meaning that you can separate with an employee for any reason or no reason at all, so they're not for cause, then those procedural and operational issues typically don't lead to, those are more of a complaining about something that is not going to trigger your pre-loss coverage. That's going to, be an internal issue that you should deal with in-house, most likely. And like we discussed before, if an employee is disagreeing about a fellow coworker, or there's been a disagreement between work duties or, some kind of personal conflict between them, again, that's more of an HR issue versus something that could potentially cause or trigger legal action. So, there is a distinction that you should be looking for, and employees are, if someone doesn't like another person or someone doesn't like the way that your district handles something internally, either procedurally or operationally, most likely that's not turning into, something that is going to become a potential employment legal issue. So then we discussed some about buzzwords, what you should be looking out for. Unfortunately, while these buzzwords are important, it seems like people are using them more and more frequently without really understanding what they mean. You hear often the words retaliation, discrimination, harassment or sexual harassment, or hostile work environment. Now, certainly if an employee says any of these buzzwords, there should be warning bells going off in your head, and you should be thinking about what they're, describing the situation as, and, determining most likely to send this to your pre-loss coverage so you can get some guidance and advice on how to handle it how to handle the situation moving forward. However, I see over and over and over again that an employee who doesn't get along with their coworker because they just don't like each other will describe the environment that they have to a supervisor or HR as a hostile work environment. That does not suffice to actually create a hostile work environment. Nonetheless, it is the safest course to engage legal counsel through your pre-loss coverage to ensure that the proper steps are taken to reach that determination, that a proper investigation, if necessary, is completed related to those allegations or that complaint. But again, we see it over and over and over again that these words are can be thrown out without a real understanding of what they mean. All right, so then one of the most critical things that every manager, HR person should be thinking about when they receive a complaint that could potentially trigger their pre-loss coverage, or that they're concerned about that could lead to a legal claim, is looking at your policies, your handbook. What do your employment policies say. So if policies, well, I think that most are fairly similar. Some districts have certain grievance procedures versus procedures related to discrimination, sexual harassment type allegations. So, if you have a grievance procedure, typically that involves more of the employee-employee conflict or employee-supervisor conflict that is dealt with internally. And, definitely follow that procedure if you have something specific in your handbook. It is important to be consistent and apply your procedures consistently throughout situations that arise. Your employment handbook should also have a specific procedure related to when you receive a complaint that could indicate allegations of discrimination, harassment, retaliation, those types of issues. That complaint can be, like we discussed, either oral or written, and you do have an obligation once you receive that complaint with those kinds of triggering words to follow up with an investigation. Now, that investigation can be done internally or externally. The pre-loss legal coverage that the pool provides is an excellent source to determine whether or not, the investigation that needs to be done whether it can be done internally with the guidance of legal counsel, or whether it would be best to hire an independent investigator to look into the issues and go from there. So definitely look at your handbook, follow it, follow the steps therein, and do it consistently for every circumstance. Do not make exceptions. Those exceptions can become problematic. If your handbook does not have a clear process, particularly related to when you get a complaint of harassment, discrimination, retaliation, please consider revising your handbook. Your handbook is a great resource and protection for your entity. So the more clear your process is and you follow it, the better protected you will be legally, both the entity and individuals who are following and enforcing the procedures. Some districts, you may be subject to an intergovernmental agreement. Those IGAs can contain certain processes afforded to employees. Sometimes there's a grievance procedure if an employee is for cause. There might be some different procedures in there to consider. Along with your handbook, if you are subject to such a document, make sure that you're following any applicable processes therein. Same with a collective bargaining agreement or an employee contract. I think that a lot of the times these kinds of agreements or these kinds of documents are a little more narrowed to certain types of districts. Obviously, I see certain fire districts being subject to potentially collective bargaining, or have in their handbook that employees are not at will, they're for cause, or certain districts have employee contracts for managers, for a district manager, those types of positions. Well, it can seem daunting. That is one of the huge benefits of getting your pre-loss, of triggering your pre-loss legal assistance, to have, someone like me or Marnie who know what to specifically look for in these documents to help guide you through a process to avoid and set yourself up in the best scenario possible to either avoid litigation or set you up for success in litigation. And so now I'm going to turn it back over to Marnie to discuss some of these issues of when to file for pre-loss versus when to file an actual claim.
Yes, so now that Ashley's given you a bit of context and a roadmap about, is this, really an everyday employment issue, and what should you do with it, versus is this something more? We're going to talk about examples of something more and whether those are pre-loss matters or claim matters. So the first example is you have a complaint through your employment policies or an informal complaint from an applicant or an employee. That is more likely to fall in the pre-loss realm than it is the claim realm. And the reverse is true. You've got an administrative charge or you have a lawsuit. So someone files a CCRD charge of discrimination or an EEOC charge. Those, along with litigation, are claim files not intended to be in the pre-loss realm. When you're looking at the complaint, as mentioned by Ashley, is it more than just general unhappiness or something that's routine for you all to be able to address in-house? So one factor is, does it contain buzzwords that you need to make certain you are more mindful of? Do you have questions about the legal implications of the complaint or the allegations in it? Do you have questions about how it impacts your policies, or you have conflicting policies? What do you do about those? Do you think that this is something you can address and then potentially resolve? That might be a pre-loss issue. Or do you think this is just the first piece in what is clearly intended to be a longer process? Meaning the employee has submitted this complaint, but also said they filed a charge of discrimination at the same time. Those will depend on whether it's pre-loss or a claim file. Also to keep in mind, what do you think your expenses are going to look like? If this is going to be a very lengthy process, then a claim file is probably more likely to be what's necessary, because the pre-loss wouldn't provide you with the amount of coverage you need. Similarly, is a settlement for something that would be covered by your policy on the horizon, because with a pre-loss claim, you wouldn't be getting any sort of assistance towards a settlement under that limited coverage. So that gives you some, more general background on the difference between a pre-loss request and a claim file. So let's drill down a little further. So you get a complaint. It has some buzzwords. You need to determine what really is your next step. You might want some help in deciding how to respond and the specific language you use in a response. You might want some help to determine, is this the type of thing you need to have an investigation done on? Is it something that you can do the investigation in-house with some guidance, or do you need a third-party investigator? You might be debating on a couple courses of action with respect to an employee, and you want some assistance understanding the risks and benefits of each of those courses of action and how best to legally defend yourself with your chosen course. Those are all things that the pre-loss would be intended to cover. Things that general counsel, some of them may be familiar with, but many times is just outside their general wheelhouse. And you really need someone who has a more in-depth knowledge of the employment laws and litigation and administrative action surrounding them. It's something you'd be paying your general counsel for, but you can implicate this coverage through the pool and not have to separately pay your general counsel for the same legal advice. I think this is important, particularly if you have documents that you want assistance in making sure that they read the way you want them to read if they are exhibits later in litigation. And I often tell clients that most people who are, working in management or HR have some level of a spidey sense. You can often have some idea about whether this is a one-off issue that you can properly address and satisfy the situation, or whether this is the start or midway through a process that's only going to get more adversarial. And when that spidey sense is triggered, that is definitely the time to think about whether or not you need to implicate the coverage. Because if you can get assistance with drafting documents that are later exhibits, you will be much happier when you have to testify about those documents, and know that they are worded in the best possible way for use by you and your organization later. Now, on the reverse, claim files involve things that are likely to be extensively ongoing. So I've had clients who initially start handling, the first complaint themselves. And the minute that first complaint comes in and the response is not automatically to the employee, oh my goodness, whatever we've done, let us rectify it, and we'll treat you like you've won the lotto. What can we do to make you happy? Because we'll do it. And that then triggers, when they don't get that response, it triggers a ton of follow-up complaints and arguments and CORA requests and a whole host of things that then trigger the spidey sense of this employee's behavior has turned a corner. And this is going to be a really extensive matter. We have, 5 different complaints against 3 different supervisors. We're likely to have, either a really large investigation or multiple investigations. The employee's already thrown out reference to a charge of discrimination with the CCRD or the EEOC. Those type of really lengthy ongoing matters are something to consider as part of a claim file. Additionally, ones with the EEOC and CCRD or lawsuits, even sometimes ones involving third-party investigations, those would be more likely to fall within the claim file realm than the pre-loss coverage. So with that background in mind, beyond the pre-loss legal coverage, there is also some additional resources that the pool provides, and those are detailed on this slide, including CPS HR, which is a human resources consulting firm with some access. And I'll let Alex mention if there's anything in particular he wants to highlight about those additional resources.
Okay, great. Thanks, Marnie. I'll just jump in real quick briefly. Obviously, what we've talked about today is more on the serious, severe end of things with employment issues and HR issues. The resources you see on the screen here are for when things aren't as serious. And so when we get requests that come to us through our info@csdpool.org email address, we're trying to determine how severe of an issue and what kind of attention it needs. So the HR helpline is a resource that's complimentary to all members. It's basically a application that you can access through your desktop. It's a broad database. There's sample HR policies, forms, best practices to look at. We mentioned revising your employee handbook. It's a great place to look for resources and examples in order to do that. There's also webinars there and free legal advice that you can ask no-cost attorneys through email or phone. But it's, again, a limited resource. Step up from that is CPS HR Consulting, again, available to all members, not just the ones with liability. And that is a partnership that we have with the organization CPS HR Consulting. And they are a management consulting firm, self-supported public agency, and they've been working in the public sector and served as a trusted advisor over 30 years. Their services include job posting guidelines, individual HR training, candidate screening, policy review, and so on. And through your membership with the CSD Pool, you have access to 10 hours of consultation at no cost. And so that's kind of a place to start. And then as things get more serious, that's where they jump into this pre-loss legal that we're talking about today.
So moving on, this slide mentions that the pool is there to provide support. So if you aren't certain is this a CPS HR matter? Is this a pre-loss matter? Is it a claim matter? What should we do? Where should we go? Paula is a specific contact you can reach out to, as well as others, including the general support number. So if you have questions, you certainly should ask. This is a coverage that you're provided, and these resources are ones you're provided as part of your involvement with the pool, and so you should feel free to take advantage of them. Alex, I don't know if you have anything else to add about this slide.
No, nothing here. Just to take advantage of the email addresses on screen. If you do have any questions or need any support, we're here to help out.
Hey, Alex, this is Diane. I just wanted to add one additional thing to this slide, which is if you're making contact with the pool for some reason, whether it's the pool administrator, a member services person, some of the risk management folks, even if you have coverage through the pool for public entity liability and you're talking to a workers' comp claim adjuster, we have procedures in place behind the scenes so that if a situation comes up in the course of those contacts, that all the people that work with the pool can get you connected to the request form to make a request for pre-loss legal assistance if you have public entity liability coverage.
So with that, are there any specific questions that anyone has for Ashley and myself, or Diane and Alex, about what we've gone through today? I know it's been a lot of information in about 35 minutes or so.
Yeah, we'll just take a second here in case anything comes through. Again, a lot of information, really great, deep dive into this. We just want to make everybody aware the resources that are available. So if something does come up, it's not cause for scrambling, and that there's opportunities here that, you can reach out, and we've handled these things before and know how to proceed. So feel free to type in those questions now. In the meantime, I see a couple people chatting. I will just promote next month's webinar. We are going to be hosting a webinar presented by somebody over at CPS HR Consulting, and it's going to be on increasing productivity with a strategic mindset. It's a little different, but if you're interested in that, you can head on over to our Eventbrite page and sign up there. And that'll be going on just in 2 weeks, actually.
I see the question for Michael, Alex.
Yes. Yeah, so Michael's question.
Yep.
Is there general language for handbooks you have on this, or can I reach out to my rep for handbook review? I would just, what I have to add, or anybody else can jump in too, that there is info through that HR helpline that we have access to. And if you would like to gain access to that, you could email us at info@csdpool.org. We could check if you already have an account or sign you up with one, and that gives you access to all of that information in there.
And Alex, in addition to that, Michael, there are some great examples of, this is Diane, there are great examples of employee manuals or handbooks. The pool does have on the same page that it posts its coverage document an overview of some of these issues and a checklist. The reason why we've got that checklist on there, it includes provisions in an employment manual to take a look at. The idea there is to take your manual or find a template that you like, and there are examples to be specific on the on some of those HR resources, not the CPS HR Consulting, but our other HR resources on the pool's website. So whether you've got one or you're taking one that you like, you can use our checklist to help draw your attention to what you might need to update. And then you can, if you choose to reach out to the pool for additional assistance through CPSHR for the 10 hours of consulting, you can use that time with CPSHR most efficiently.
All right,
And
the question came
answer
through.
to
Oh, sorry, go ahead, Marty.
In answer to Lisa's question, yes, my understanding is Alex mentioned the slides will be available as well as a recording of today.
Yes, that's correct. We got this recorded. We'll be sending it out later today for review.
And Alex, this is Diane. Well, this next question, we've got a nice comment. I just wanted to, I have a different role with the pool as general counsel, and I wanted to share, my appreciation for Marnie and Ashley, not just for presenting today, but I think this came up before, but they are on our pool panel. And both of these folks were on the pool panel for defense, but they have a background that is really well suited to pre-loss legal. It is a specific kind of practice. I've done a lot of general counsel work, and the work that they do is different and requires expertise and and experience. So I think that it is really helpful to take these serious situations that Marnie discussed on those example slides. A lot of those situations that are serious but haven't matured into a lawsuit or federal EEOC complaint or similar are the types of situations where if things are getting serious, where pre-loss legal can be extremely helpful to get some of these panel folks in place to help your district with best practices and with procedural compliance. Their assistance is really valuable to avoid those serious claims and to resolve these issues with dignity for everyone. So I'm so grateful to you both for being willing to present today.
We appreciate that, Diane. And it looks like there's one more person typing, so maybe we'll wait to see if that's a question. Oh, just an appreciation. Well, we appreciate everyone's time this morning. Ashley and I are always available if you just need to pick our brains, and you've got a bunch of great resources through the pool.
All right, fantastic. Yeah, I want to echo Diane and thank you, Marnie, and thank you, Ashley, for presenting today. Thank our membership, too, for taking some time out of your day to join us and go over some pre-loss legal information. Again, the links there are available to, make sure you have those written down. If you have any questions, info@csdpool.org. We'll get it to the right people. File slides are available for download today, too. And again, we'll be sending out a recording to everybody. So any last words or anything to leave the membership with, Marnie or Ashley?
I would just say, hopefully you don't need to implicate any of this, but it's there if you do.
I would echo that, and just that we love working with the pool, and think that there are excellent resources that can really help protect your districts, and we both love the work, so we appreciate it.
All right, fantastic. And Diane, thank you too for being here today, rounding out our session. And I think with that, we'll wrap things up and say goodbye for the day and see you in a couple weeks.
Bye-bye, everyone.